Trial by jury. Thomas Jefferson called it the only anchor ever yet imagined by man that can actually hold a government to the principles of its constitution. And jury nullification is how you get it done, which is probably why the government doesn't want you to know about it, doesn't want you to learn about it, doesn't want you to use it ever. So on this episode, I've got a bunch of info on jury trials, on trial by jury, actually, which we'll learn about, and jury nullification from the founders and the old revolutionaries, plus the best essay, I think, ever written on this, which was written by Lysander Spooner. And we're going to break down what it is, the history behind it, how it works, and I think you'll see why jury nullification matters today more than ever. But first of all, before getting to that, welcome, and thank you for joining me here on the Path to Liberty. My name is Michael Bolden with the 10th Amendment Center, and this is the show for Wednesday, October 9th, 2024. Hope you're having a good day so far. Let's get right to it. And we want to start out with FIJA, Fully Informed Jury Association, with this page, what is jury nullification? A quick introduction to what it is. And they write, in its strictest sense, jury nullification occurs when a jury returns a not guilty verdict, even though jurors believe beyond a reasonable doubt that the defendant has broken the law. So even though they all say, well, yeah, okay, the facts of the case say, well, the law was broken, but we're still going to render a verdict of not guilty. Basically nullifying the law in practice and effect and setting the person free despite breaking that law. And they say because the not guilty verdict cannot be overturned and because the jurors cannot be punished for their verdict, and we're going to get into the history behind that as well, going to the 17th century, the law is said to be nullified in that particular case. Really important stuff, a very powerful tool. Thomas Jefferson again called it the only anchor that humankind has ever invented that can keep a government to its principles of its constitution. Going further, they have another version of jury nullification. They say in what can be said to be a milder form of jury nullification, some of the jurors, or even just one in most cases, can hang the jury by maintaining a not guilty verdict even though they believe the defendant broke the law. If the jury cannot unanimously agree on a verdict of either guilty or not guilty, this is known as a hung jury. When further deliberation clearly will be unproductive, the judge might declare or will declare a mistrial. The prosecution may or may not retry the case in the future, but the law has at least been nullified in the trial at hand. So it's been at least temporarily nullified. And then another jury could do the same and make it permanent as well. And this is a long tradition in American history and much earlier as well. And we can start out here with John Jay, the first Chief Justice of the United States. Here he is in the case of the state of Georgia versus, I believe, Brailsford. This is 1794, and he's got this section, this charge to the jury where he explains that they can actually choose to vote not guilty, even if they think they the person broke the law. It may not be amiss here, gentlemen, to remind you of the good old rule that on questions of fact, it is the province of the jury. On questions of law, it is the province of the court to decide. But there's more. There's a caveat here. He said, but it must be observed that by the same law which recognizes this reasonable distribution of jurisdiction, you have nevertheless a right to take upon yourselves to judge of both and to determine the law as well as the fact in controversy. So you're not only just judging the facts of the case on a jury, you are actually judging the law, whether it should even exist. And that's what makes it so powerful. John Jay continues with this. He said, on the one hand, it is presumed that juries are the best judges of facts. It is, on the other hand, presumable that the court are the best judges of the law. But still, both objects are lawfully within your power of decision. So, to me, we could just wrap it up with that, really, because ultimately, when it comes to the law and the Constitution, and the structure of the Constitution, the first Chief Justice, John Jay, knows way more or knew way more about the Constitution than anyone alive today. I don't care what they happen to say about it. They know more than you, than me, than all of us. And so John Jay was kind of a go-to guy on this. But Thomas Jefferson also considered this very important. And in his notes on the state of Virginia, 1781 to 82-ish, depending on what part you're reading, he said, these magistrates have jurisdiction both criminal and civil. If the question before them be a question of law only, they decide on it themselves. But if it be of fact or of fact and law combined, it must be referred to a jury. In the latter case of a combination of law and fact, so the law itself, you're judging the law, just like John Jay said years later, or you're judging the facts of the case, he said it's usual for the jurors to decide the fact and to refer the law arising on it to the decisions of the judges. But this division of the subject lies with their discretion only. So it is just up to the jury to decide if the jury wants to judge the law as well as the facts of the case, and no one can give them instructions on whether or not they're allowed to do so or not. Well, they may try to, but the jury has the right to do what it wants. And if the question, Jefferson writes, relate to any point of public liberty, or if it be one of those in which the judges may be suspected of bias, the jury undertake to decide both law and fact. And in the Philadelphia Convention, what we often call the Constitutional Convention in 1787, Elbridge Gerry, we often call him Jerry because of gerrymandering, but his real name was pronounced Elbridge Gerry, I learned in the last couple of years. He gave a great reason overall why the founding generation considered this tool to be so important. We see a little bit of that from Thomas Jefferson as well. But Gerry said, juries are necessary to guard against corrupt judges. I would also add, they are necessary to guard against corrupt, unconstitutional, immoral, unjust laws as well. But this is an important part of this tool. William Findley in the Pennsylvania Ratifying Convention, this is December of 1787, pointed out that when Sweden actually stopped using the trial by jury, the people lost their freedom because this was such a powerful tool. And here from the notes on this, or a report on it, Mr. Findley observed that when the trial by jury, which was known in Sweden so late as the middle of the last century, fell into disuse. I don't believe, because I don't know the history of that super well, and there was actually some debate on this in the Pennsylvania Ratifying Convention as well, December of 1787. My understanding is that they just stopped using it, not that it was banned, but when it fell into disuse, he said, the commons of that nation lost their freedom and a tyrannical aristocracy prevailed. So Findley was an anti-federalist, but many of the founding generation recognized that without the trial by jury, because of this power to judge the law and the fact, what we call today jury nullification, when that's gone, government can just get out of control because this is the last line of defense of a peaceful response to usurpations of power. Now, the response from James Wilson, and I forget the name of the guy, the Chief Justice of the Pennsylvania High Court or Supreme Court, they basically said, this guy Findley, he's just some farmer. He doesn't know what the heck he's talking about. Sweden never even had the trial by jury. And Findley was pretty upset. And so the next day he brought evidence that said, look, why am I the guy having to point out to these people who are supposed to be the top legal minds that this was the case? So this is an important piece of that history as well. We also see trial by jury in the Declaration of Independence as well. It is one of the grievances, the injuries and usurpations, abuses of power by the British for depriving us in many cases of the benefits of trial by jury. And that was a similar grievance to what was listed in the Virginia Constitution, which was approved on June 29th, 1776, drafted primarily by George Mason and a few others, but really important stuff. It's cool to see out in the chat. I'm going to get back to you guys in a moment. Someone with a screen name, Lysander Spooner, saying, I approve this message. We're going to get a lot into Spooner here after the middle part of the show as well. Clay S. Conrad, who wrote probably one of the best books on jury nullification, has an interesting post from many years ago on a trial by jury over at the Cato Institute. And you can learn pretty quickly reading through this that it wasn't the founders who actually invented all of this. It was a big part of their long-standing legal tradition and their customs to have a jury be able to judge both the law and the fact. And Conrad put it like this: British courts guaranteed the independence of criminal trial juries in 1670. In a case concerning 4 jurors who had acquitted William Penn for illegally preaching about his Quaker beliefs. So, I mean, you get so many levels of government oppression on this. 1, government trying to stop people from having freedom of speech. 2, government trying to stop people from having freedom of religion. And 3, government trying to stop people from being able to exercise their judgment on a jury, on a trial by jury. And so those jurors, he writes, were imprisoned for their not guilty verdict because they had ignored the trial judge's instructions to vote for Penn's conviction. An English appellate court released the jurors from prison, establishing the principle that juries cannot be punished for bringing in the so-called wrong verdict. I like that Conrad put wrong in scare quotes because when the jury makes a decision, it isn't wrong. We may disagree with it, but their decision is supposed to be final. The freedom, he writes, of American jurors to vote according to conscience can be traced to that landmark precedent. So this was a huge part. Everyone understood what this was all about. And Blackstone talked about this as well, because from my understanding, trial by jury was also included in the English Bill of Rights in 1689, maybe not as expressly as some would have liked, but here's how Blackstone put it later. The glory of English law. This was written around 1765 or so, around the time of the Stamp Act. The trial by jury ever has been, and I trust ever will be, looked upon as the glory of the English law. Now, the reason that trial by jury is so important is not just because it is a jury of peers being able to say someone from the neighborhood is guilty or innocent. It's because this is a tool that can actually keep government in check. And of course, they never teach us about that latter part of it. And as I was going through my notes on this, I think this was just published yesterday by Brittany Hunter, who has done awesome work over the years. She now works over at Pacific Legal Foundation. I think she used to write for fee.org and a few other places as well. Brittany, really awesome article on this. This will be linked to in the show notes. I'll mention that again in just a minute as well. And so she actually talked about some of the history in colonial America. In 1733, she writes, Governor William Cosby, the British colonial governor of New York, took legal action against the printer and journalist John Peter Zenger. This is a name that actually comes up even in the ratification debates. They named Zenger, they named 1735 as an important turning point. Zenger's paper, she writes, had printed articles of satirical materials. Muckraking was a big deal back in the 18th century. They used to really hammer on people. But he published satirical materials criticizing the governor, with the latter accusing him of seditious libel. Again, this is about freedom of speech, freedom of expression. Without freedom of speech, what can you do to challenge and spread awareness about what government does? That's why we have to think about this in much broader terms than just the jury as well, because we can see why this tool is being used. Cosby, she writes, became irate after 2 grand juries refused to indict Zenger. Cosby then used a tactic called information to have Zenger tried in front of the New York Supreme Court, which he was in control of. But yet, and much to his dismay, the jury found Zenger not guilty. Now, there was a publication that I think Zenger did, The Narrative of the Trial. Benjamin Franklin in 1736 published this, and there were a lot of copies sold. I don't know the number, but the case was widely known, this tool, this trial by jury. And so as you get into the years early part of the American Revolution leading up to the War for Independence, everyone understood that this was a tool that was keeping these colonial governors, these British governors, in check. It was widely known how things went down. And I've actually seen a lot of places, if you do some searching on this, you'll see a lot of places citing a quote from Governor, I'm not sure how to pronounce it. I've often had it different ways, and I've done some research. The penman of the Constitution, the guy who drafted the preamble to the Constitution, Governor Morris. He said that the trial contained the germ of American freedom, the beginning of the American Revolution. I've not been able to find the original source on that yet, so if anyone else does, please leave it in the comments or send me an email over at team@10thamendmentcenter.com. And while I'm here, I should reiterate that all of these source documents, these articles that I'm mentioning, etc., they will all be linked to in a single blog post for this episode, just like we publish for every single episode. That'll be over at 10thamendmentcenter.com/path to liberty. Alan Mosley does such awesome work, so consistent on doing this. I'm very grateful for him taking this off my plate. It saves me some time every Wednesday, Friday, or Monday, Wednesday, and Friday when I'm on schedule. He gets that organized with a show links section, plus all the different platforms are on. Of course, we live stream on the mainstream ones like X and YouTube and Facebook and Twitch and LinkedIn and elsewhere. We also live stream at Odyssey.com and Rumble.com in case you're looking for another platform to check us out on rather than one of the mainstream ones. And we have the audio-only podcast edition all over the place. So Alan will get that organized, and I will get it published over at 10thamendmentcenter.com/path-to-liberty. a couple of hours after this live stream is done. And while I'm here, I want to take a quick moment to say hello to everyone out in the live chat. Again, I appreciate you being here. Whether this is your first episode or you've been here for every single one since day one, it is awesome that you spend time with me on this important historical information. I really appreciate it. There's Lysander Spooner again, Brewster and Kirk, Diana, good to see you, Howard, Jin of Eve. I think I saw somebody said, George Donnelly, pretty cool to see you. I appreciate your work as well. Wasatch Andy, Blindly Follow, and a bunch of other Agorizer, etc. Thank you again for being here. But let's get back to it. We're talking about Blackstone again. He has a whole chapter in Book 3 on his commentaries. Chapter 23, Book 3, on the trial by jury. And this will be linked to in the show notes as well, because you're going to need to read about this a little bit more in context on your own time. But one point that I want to make here before we get into Lysander Spooner is what Blackstone called the trial by jury. He said, the subject of our next inquiries will be the nature and method of the trial by jury, called also the trial per pe, or by the country. Trial by the country is a very important phrase, and Spooner used it in his great essay on the trial by jury in 1852 over and over and over, because that's the important point. It's either a trial by the country, representatives of the people of the country, or it's a trial by government. And if government gets to try itself, in essence, if you're talking about judging both the law and the fact, as Spooner, you'll hear him make the case, that means government's power is unlimited. And here is Spooner from that essay. The object of this trial by the country, or by the people. Again, just before that, he said the trial by jury was anciently called trial per pe, just like Blackstone put it, or trial by the country, which is what that translates to. And the object, in preference to a trial by the government, is to guard against every species of oppression by the government. Every species of oppression. This is a tool to guard against it, because if their say is final on the jury and government is trying to prosecute a bunch of people for doing a bunch of stuff, they're not going to be able to get away with it. And that will encourage more people to do stuff that government says they can't do. We should see jury nullification in the war on drugs, in the war on the right to self-defense, in the war on virtually anything and everything. And Spooner continues. In order to effect this end, it is indispensable that the people, or the country, judge of and determine their own liberties against the government, instead of the government's judging of and determining its own powers over the people. And he asks the essential question. It's rhetorical, but I think it makes sense. How is it possible that juries can do anything to protect the liberties of the people against the government if they are not allowed to determine what those liberties are? And that really is the foundation of what trial by jury is all about. Trial by the country, jury nullification. And Spooner continued. He continued with this. Any government that is its own judge of and determines authoritatively for the people what are its own powers over the people is an absolute government, of course. And he said there is no more accurate definition of despotism than this. And that's what Thomas Jefferson talked about back during the Revolution, of course, in his Kentucky resolutions of 1798. Any government that can determine the extent of its own powers has unlimited power. Any people of any state who would allow somebody outside of themselves to make a determination of how that government has power, well, they are under unlimited power of whoever may make those decisions for them. I'm just trying to paraphrase that off the top of my head. Kentucky Resolutions of 1798 is what you'll want to look up for that. Now, this process, anyways, going further, I'm going to get to the process of how and why they choose the jurors by lot as well, what Spooner has to say about this. And he said, on the other hand, any people that judge of and determine authoritatively for the government what are their own liberties against the government, of course, retain all the liberties they wish to enjoy. So ultimately, this is an expression of sovereignty or final authority. This is a part of the system that tells us that government isn't in charge of itself. And Spooner says, and this is freedom. Of course, it's freedom to them because at least they're making the decision about how much freedom they want to have. And now he gets into why the jurors are chosen by lot. And again, Spooner, I think, does better on this than anybody I've ever read. He said, to secure this right of the people to judge of their own liberties against the government, the jurors are taken, or must be to make them lawful jurors, from the body of the people by lot, or by some process, any process that precludes any previous knowledge, choice, or selection of them on the part of the government. Because as soon as government gets involved, then government is dictating the results. And we don't want government to have power over government. That is not a land of the free. That is a definition of a population on its knees begging for scraps, really. And that's what Spooner gets to as well here. He said, this is done to prevent the government's constituting a jury of its own partisans or friends. In other words, to prevent the government's packing a jury. We hear about packing courts, but they also pack juries to get guilty. Well, they use a lot of pressure. They use a lot of ways to do that, with a view to maintain its own laws and accomplish its own purposes. So really, if you think about it, the underlying motivation for government is to maintain prosecution in the stuff they have on the books. They're not going through this process just to, well, repeal laws. There's no way. And it's supposed to be the process, according to Spooner, the way he explains it, even though it is only 12 people, the goal is to have a fair epitome, is what he called it, of the country at large. And he said, and not merely of the party or faction that sustain the measures of the government. And as I was just mentioning, this really is a part of the entire system that reinforces that the people are supposed to be in charge. Well, the people are in charge. They just don't act like it. But the people are supposed to be in charge, and government is really supposed to be their agent, just their tools to do certain stuff that they decide they want them to do. George Mason put it like this in the Virginia Declaration of Rights in 1776. All power is vested in and consequently derived from the people. Magistrates are their trustees and servants, and at all times amenable to them. And with that, let's get back to Lysander Spooner. And he put it like this. As unanimity is required for a conviction, it follows that no one can be convicted except for the violation of such laws as substantially the whole country wish to have maintained. So ultimately, trial by jury and what we call jury nullification today is about the people deciding what government is going to be able to enforce. And this is really asserting the authority of people over governments. James Wilson once put it, he says, as our constitutions are superiors to our governments or our legislatures, so the people are superior to their constitutions. The people have the final say. And this is one of the best tools to assert that final say. Spooner continued. He said, the government can enforce none of its laws by punishing offenders through the verdicts of juries, except such as substantially the whole people wish to have enforced. The government, therefore, consistently with the trial by jury, can exercise no powers over the people except such as substantially the whole people of the country consent that it may exercise. And Spooner, in some later papers, talks a lot about consent. I've done an episode on that. I wish I had a link to it, comparing Locke's version of consent versus Spooner's much more individualist approach to consent. But again, this is about consent because you're not free if there is no consent. And this is an assertion of that consent. He said, in such a trial, therefore, the country or the people judge of and determine their own liberties against the government, instead of the government's judging of and determining its own powers over the people. And of course, we think of Spooner as being very radical in the 19th century, but he was really just reiterating many of the same principles that the founding generation told us. Of course, Thomas Jefferson told us that if free people claim their rights as derived from the laws of nature and not as a gift of their chief magistrate. So it's not liberty if it requires government approval. It's not liberty if it requires a government permission slip. And Spooner's saying almost the same thing. John Dickinson told us that when government has, when you have a bad administration, so in essence, every administration we've ever lived under has always been a bad one because they aren't within the bounds of the Constitution, or we wouldn't be living under the largest government in history. But Dickinson said, when you have a bad administration, what is to be done? He said the answer is found before the supreme sovereignty or final authority of the people. He said it is their duty to watch and their right to take care that the Constitution be preserved, or in the Roman phrase, on perilous occasions, to provide that the republic receive no damage. This is a huge part of the people providing that the republic receive no damage, because if the government can't prosecute people, then their laws may be on the books, but nullified in practice and effect means the people are able to live much more freely. And this was given as a leading reason to ratify. Some of the Federalists really kind of pointed to this powerful tool as, kind of to alleviate concerns from the Anti-Federalists. For example, in the Massachusetts Ratifying Convention in early 1788, the Anti-Federalists were on the path to defeating the Constitution, defeating ratification. And some of the leading Federalists, Theophilus Parsons, who was a great legal mind, he was a powerful speaker, not to the level of Patrick Henry. He ended up being the Chief Justice of the Massachusetts Supreme Judicial Court, I think it's what it's called. He later held in the 1800s that the militia of Massachusetts could not be constitutionally released for Mr. Madison's War. We're going to cover that in a future episode sometime soon. But very important on the Federalist side. And here's how he put it. He said that even if the federal government goes beyond the limits, hey guys, if you are concerned about ratifying, don't sweat it, because we can nail this down right here in Massachusetts anyways, because we, the people, can stop them dead in their tracks. And here's how he put it, much better than I can. The people themselves have it in their power effectually to resist usurpation, without being driven to an appeal to arms. An act of usurpation is not obligatory. It is not law, and any man may be justified in his resistance. Not obliged, but justified. Now, other people would have said it would be a duty. Someone like Samuel Adams would say it is our duty to take a stand, to defy usurpations of power, unconstitutional acts. But Parsons is saying you're justified in saying we're going to resist this. He said, let him be considered as a criminal by the general government, yet only his fellow citizens can convict him. They are his jury, and if they pronounce him innocent, not all the powers of Congress can hurt him. And innocent they certainly will pronounce him if the supposed law he resisted was an act of usurpation. So this was a leading example of why they decided to ratify. This was part of the argument, was saying, look, we have this tool. Of course, we understand you're worried that they're going to go beyond their limits. We need more words on paper to stop them. But ultimately, it is up to the people to protect and defend their own Constitution and their own liberty, whether the government likes it or not. And Spooner, I think, sums it up really great here. He said, in short, if the jury have no right to judge of the justice of a law of the government, they plainly can do nothing to protect the people against the oppressions of the government, for there are no oppressions which the government may not authorize by law. So government, if they don't have anything keeping them in check, will continue to do more and more and more. And if you put it all together, a real or a true trial by jury, trial by the country, using jury nullification, it means that the jury must not only judge the facts of the case itself, but also the admissibility and the weight of all the evidence offered. They judge the true exposition, what the law itself means. They judge the justice of the law, and they also judge the very existence of the law. And I think that's why Thomas Jefferson, in this letter to Thomas Paine in 1789, he said, I consider trial by jury as the only anchor ever yet imagined by man, by which a government can be held to the principles of its Constitution. Well, I hope you guys found this interesting. I hope it was educational. I think this is incredibly important to get out to more and more people, because it really is our last line of defense, of peaceful resistance to the largest government in the history of the world and its 50 vassal states that basically do whatever it wants in most situations. And nothing helps us get this kind of essential information out to more and more people, more than the financial faith and support of our members. You can join us for as little as $2 a month over at 10thamendmentcenter.com/members. We also have annual, 5-year, and lifetime options. Again, 10thamendmentcenter.com/members. No pressure, but if you got a couple of bucks of that dirty government fiat, please consider throwing it our way. We punch way above our weight class here at the 10th Amendment Center, and I'd be very grateful for any consideration you can give to joining us today. Again, 10thamendmentcenter.com/members. I really appreciate you spending some of your time with me today. I hope you enjoyed this episode. I hope it made you think. And more important than anything, I hope you learned something. We'll get that blog post published in a couple of hours. And I look forward to seeing you next time here on the Path to Liberty.